Sarla Mudgal versus Union of India, AIR 1995, SC 1531. The verdict laid down the principles against the practice of solemnizing second marriage by conversion to Islam, with first marriage not being dissolved. Facts of the case: the court heard 4 petitions filed under Article 32 of the Constitution, under the provisions of which individuals may seek redressal for the violation of their fundamental rights. The petitioners filed a case against the practice of solemnizing a second marriage by conversion to Islam without dissolving the first. The first petition was by Kalyani, which is an organization that works for the needy families and women in distress, which headed by Sarla Mudgal. The second petitioner was Meena Thakur, married to Jitendra Mathur in 1988. Meena finds that Jitendra converted to Islam and solemnized second marriage with Sunita Narula, also known as Fatima. Meena Mathur complains that her husband converted to Islam only for the purpose of getting married again and circumvented the provisions of section 494 of IPC. The third petitioner was Geeta Rani, was married to Pradeep Kumar. She alleged physical and mental violence by her husband. She later found that her husband Pradeep eloped and married another woman after converting to Islam in 1991. Fourth petitioner was Sushmita Ghosh. Sushmita Ghosh married to Jishi Ghosh according to Hindu rituals in 1984. On 1992, the husband told her that he no longer wanted to live with her, and as such, she should agree to divorce by mutual consent. The petitioner was shocked and prayed that she was her legally wedded wife and wanted to live with him, and as such, the question of divorce did not arise. The husband finally told the petitioner that he had embraced Islam and would soon marry one Vinita Gupta. In the writ petition, the petitioner has further prayed that her husband should be restrained from entering into marriage with Vinita Gupta. Questions of law: whether a Hindu husband married under Hindu law by embracing Islam can solemnize a second marriage, whether such a marriage without having the first marriage dissolved under the law would be a valid marriage when the first wife continues to be Hindu, whether the apostate husband would be guilty of the offense under section 494 of the Indian Penal Code, whether the husband can be charged under section 494 of IPC. Decision of the court: it was held by the court that no authority could be found to support the view that a marriage solemnized according to one personal law can be dissolved according to another personal law, simply because one of the two parties has changed his or her religion. The court held that under the Hindu personal law, even after one of the spouses converted to Islam, there cannot be no automatic dissolution of marriage. If there were to be an automatic dissolution due to conversion, it would amount to destruction of the existing rights of the other spouse who continues to be Hindu. Recognizing that the existing Hindu law strictly enforces monogamy, the court held that a marriage solemnized under the Hindu Marriage Act 1955 cannot be dissolved in any other way except on the grounds available within the act itself, and that a second marriage by an apostate under the shelter of conversion to Islam would still be a marriage in violation of the Hindu Marriage Act, which governs their first marriage. The court therefore held that under the Hindu personal law as it existed prior to its codification in 1955, a Hindu marriage continued to subsist even after one of the spouses converted to Islam. There was no automatic dissolution of the marriage. The real reason for the voidness of the second marriage is the subsisting of the first marriage, which is not dissolved even by the conversion of the husband. The second marriage after conversion to Islam would be in violation of rules of natural justice and as such would be void. The court held that the first marriage would have to be dissolved under the Hindu Marriage Act 1955. In the present case, it was not dissolved according to the Hindu Marriage Act. Therefore, the marriage is still valid, and under Hindu law, his second marriage, solemnized after his conversion, is illegal under section 494 of the Indian Penal Code 1860. The second marriage of a Hindu husband embracing Islam, being violative of justice, equity and good conscience, would be void on that ground also. and attract the provisions of Section 494 of Indian Penal Code. Moreover, the court said all the 4 ingredients of Section 494 of IPC are satisfied in the case of a Hindu husband who marries for the second time after conversion to Islam. He has a wife living, he marries again. The said marriage is void by reason of its taking place during the lifetime of the wife. The court therefore holds that the second marriage of a Hindu husband after his conversion to Islam is a void marriage in terms of Section 494 of IPC. Observing that each of these ingredients were present, the court held that the act of Hindu husband solemnizing a second marriage after converting to Islam during the subsistence of the first marriage attracts Section 494 of the Indian Penal Code. Uniform Civil Code. In reiterating the pressing need for a uniform civil code, the court recognized that the role of the judiciary as a reformer and enforcer of the vision of the Constitution and emphasized the desirability of a uniform civil code for the protection of the oppressed and promotion of national unity and solidarity. The Sarla Mudgal judgment has issued no direction for the implementation of Uniform Civil Code, though Justice Kuldeep Singh has requested the government to look at the Article 44 of the Constitution. Thank you so much for giving me your valuable time. I hope you liked the video. If you have any doubts, do let me know in the comment. I will try in the best possible way to clear those doubts. And do subscribe the channel as I'll be posting regularly such law contents. Till then, Ricky signing off. Peace.